Oh my goodness. A couple of weeks ago, I was on a virtual status conference with my client, with the judge, and with the other party who's not represented by an attorney, and also with a court-appointed advisor. And I was shocked, but kind of not shocked by the other party who was on camera, wearing a ball cap, leaning back in his chair, smacking on some gum. So that inspired me to make today's video, which is about the 10 oops moments that you should not be making in your family law case. Stay tuned. My name is Wendy Hernandez, and I'm the creator of Command the Courtroom. I'm also a Phoenix family law attorney. I've been practicing for about 25 years, maybe a little bit more. I have made hundreds and hundreds of videos for people just like you who are going through a child custody battle in the family law courtroom. Look at all the videos that Command the Courtroom has to offer. Be sure and sign up for that best interest checklist if you haven't already. If you watch this video and you like this video, please give it a thumbs up. Give any other videos that you like a thumbs up. I noticed that most people don't give thumbs up. I'm not sure why, because they're anonymous, but giving the video a thumbs up helps me bring more videos to you. And also, if you hit that subscribe button, then you're going to get notified each time I release a new video. Let's get on to the topic of the day, the top 10 oops moments that I've seen in family court that I don't want you to make. So my first not to do in the family law courtroom goes along with don't wear hats, don't chew gum when you're in the courtroom. I don't care if it's a virtual court appearance or an in-person court appearance. Another thing, a court is a place that demands respect. I know that a lot of you don't feel like you're respected in the courtroom, but a judge wants to feel as though he or she is respected. And since that person is the person deciding your case, do the best you can to show the judge respect by dressing appropriately. Think about it like going to church. How would you dress to go to church? Dress professionally. Don't wear low-cut tops. Don't wear straps, spaghetti straps. Don't wear shorts. Don't wear flip-flops. Don't go strolling into court with a drink in hand or with snacks in hand. And I've actually seen people do that. Treat the court with respect. Show up like you're serious, because if you don't, a judge isn't going to think that you're the more responsible parent, which is exactly what you're trying to show. All right, this is my hot tip number 2. When you are presenting your case at an evidentiary hearing, a trial, a temporary orders hearing, an order of protection hearing, you have to pick the information that is most relevant to the issues in dispute. In other words, this means that you don't go on about every single little thing that your ex has done since the beginning of time to wrong you. And yes, some of those things may be relevant if you're trying to prove a significant domestic violence or a significant history of domestic violence. Acts going back even 20 years could be relevant, but you have to ask yourself very seriously, is the judge going to want to hear this? If you don't pick what your evidence is going to be carefully, then a judge is going to just hear a bunch of noise, like, you know, the womp, 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 womp in the Charlie Brown shows. It starts to feel the same. Pick out the most important information that is going to impact your case the most. Think about the things that your ex has done related to you or to the kids, or the things that your ex has not done related to you or the kids. That's going to convince the judge that you should get the custody arrangement and the parenting time arrangement that you, and most importantly, that the kids deserve. All right, so do not do number 3. Don't go crazy on social media when you're in the middle of a child custody case. Please, I beg of you, don't do it. And I don't know why people don't learn this lesson. I don't know why people haven't thought about it, but oftentimes in almost every case I have, I see people posting crazy stuff that's going to hurt their case on Facebook, on TikTok, on Instagram. Don't do it. If you're going through a family law case, it's best if you just make your profile private so only your friends and family can see it. And even at that, you can't be totally sure that a friend of yours that's also a friend of your ex's isn't spying, because I've had it happen in more than one case where there has been a mole who is grabbing screenshots from posts on Facebook and TikTok and Instagram, and then they show up as Exhibit A in the courtroom. Mind your P's and Q's. You don't need to post every little thing you're doing. You don't need to post about the Girls Gone Wild weekend in Mexico, especially if you're claiming that you're not able to support the kids. Don't post about excessive drinking, nights out with the guys, especially if you say you don't have an alcohol problem. Just because you're going out with the guys or going out with the girls doesn't mean you have a problem. them, but your ex is going to use it to say you do. Keep your business private. Tip number 4, be on time for your court hearing. If you're not early, you're late. So show up early. Plan to be at the courthouse at least a half hour early. You never know what's going to happen on the way. There might be an accident. You could break down. Who knows? But get there early. I once had a case that we tried the entire case and the other party wasn't present. My client, because he was the only one who presented any evidence, got every single thing he wanted, including sole legal decision-making authority over the children and very limited parenting time to the parents who didn't show up. Well, just as the judge was slamming the gavel down, here comes the other party strolling into the courtroom with some story about why she was late. Meanwhile, there hadn't been a call to the court or anything like that. The person just showed up late. She thought she was going to be able to undo the judge's decision, but it was too late. The judge had already called the scene and it was over. There was nothing this person could do. And while I thought that the result was in the best interest of the children, if it had not been, it would have been very problematic for this parent and most importantly, for the kids. Be on time, be early. Going to court is very stressful, and especially if a judge wants to hear from you. I get it, and that's why it's important to outline your testimony and role play it, but please don't come up to the stand with a 10-page single-spaced document that you intend to read word for word for your judge. It may have good information in it, but it's not going to come off as very authentic or genuine. The judge is not going to be able to see the real you because you're going to sound like a robot. And I also will tell you, my eyes tend to glaze over when I see somebody walk into the courtroom or walk into my office with a 15-page document and they're going to read it out loud. I want to hear from the person. I want to know who the person is. I want to see the emotion on their face. I want to see their expressions because this is part of what makes up credibility. It's going to be difficult to remember everything, but that's why you need to get prepared in advance. Don't read a script. If you're going to have a script, then try to memorize your major points and fill in the blanks. So for tip number 6, this is one of my favorite things to talk about, but not one of my favorite things to deal with when it happens in the courtroom, and it happens way more than it should. And that is surprise evidence. A lot of times people think that they're going to show up with the smoking gun for the first time and surprise the other side and convince the judge this is why they should get custody or parenting time. Surprise evidence rarely works. The court has rules in place that require you to disclose evidence according to certain timelines. Follow the rules. Look at your court's minute entries. Look at your jurisdiction's rules. Look at the rules of procedure because you're risking it. If you haven't disclosed the right evidence prior to trial, there's a huge chance that you're not going to be able to use it. There's a small chance you might be able to use it, but are you willing to take that risk if the evidence is that important? Please disclose your information ahead of time. Get it ready to go. Follow the court's orders and provide it to the other side because there is no trial by ambush. That's not the way it should work. Think about whether you would like that or not, and I'm pretty sure you wouldn't. The next tip is number 7. I call it evidence overload. Don't do it. And what I mean by that is just going to trial and just dumping 300 or 4,000 pages into evidence and expecting the judge to sort through it and figure out what's relevant and how it applies to your case. So I have been in trials before where there's an attorney on the other side and we may have 100 exhibits and the other attorney says, hey, just to speed the trial up, would you be interested in just stipulating to the admission of the evidence? And of course I want to do that because that leaves me more time to talk with my client about the relevant issues. However, even if we do that, if a piece of information is really important, I single out that information in my client's testimony and I point the court to the part of that information that really matters in the case. And courts like it when you do that way. I've had judges tell me, Ms. Hernandez and Mr. So-and-so, you can stipulate to the admission of this 100 exhibits, but I am not going to look at it unless you tell me how each individual piece of evidence matters to this case and to the issues and disputes. So don't just back up a dump truck and dump it on the court. Make your judge's life easier to the fullest extent possible because that's going to help you. Okay, on to the next tip. I want you to know that you don't have to use legal jargon in the courtroom. And one of the things that I see people doing, especially if they're representing themselves, is trying to look and act smarter than they feel by using all kinds of terms and phrases that they don't really understand. I learned a lot during my first year of law school. In fact, I felt like I was learning a new language with all the legal terms and phrases that I had to get to know. But I've spent the last 20 plus years unlearning how to talk to people that way, because that's not the way that I get my clients to understand what I'm saying. And it's not necessarily the way that I get judges to pay attention to what I have to say. Don't feel like you have to use legalese when you're presenting your case. By all means, if you feel really comfortable with the terms and you know that you know what they mean, then use them. But if you're not sure, don't let it make you feel less than. Don't let it impair your confidence. You don't have to use legal jargon in the courtroom. All right, so this is my hot tip number 9, and that is, what do you do with your emotions on the stand? And I always tell my clients, like, I want you to be authentic. I want you to be genuine. You know, if you feel like crying, it's okay to cry. If you feel like you need a couple of moments while you're on the stand, then tell the court, tell me, and we'll take a couple of moments so you can gain your composure, but don't totally lose control while you're on the stand. That shows something to the court. I don't know what the court is going to take from that, but you have to get yourself under control. You have to be able to manage your emotions while you're on the stand. If you have an attorney, work through how to do that with your attorney. And if you don't have an attorney, then again, I'd recommend, prior to going to your court hearing, role playing with friends and family, outlining that testimony and knowing what you're going to say, so it's not raising these emotions that you're not expecting. And you could have emotions that come up that you don't expect, but do your best not to let those emotions get the better of you, because if you do, then you really risk not getting that information out to the judge that the judge wants to hear and needs to hear. So the biggest oops that I see people make when they're in the courtroom is forgetting about the main star. And who is the main star? It's not you, it's not the judge, it's not your ex, it's your kids. You have to remember that you have to focus entirely on the best interest of the children. That is how the court is going to make decisions about your kids and what the parenting plan is going to look like. And as I mentioned before, and as I mentioned in almost all my videos, if you haven't already downloaded that best interest checklist, do it now. It's very popular, and in the checklist, you're going to learn about the factors the court must consider in making decisions for your children. So during your trial, don't get caught up in your ego. Don't get caught up in your pride. Focus on what matters. Stay focused, aligned, and laser sharp on the best interests of your kids. So that's going to do it for my top 10 oops moments that I've seen people have in the courtroom. I hope they helped you. I hope you like them. They're going to get you 10 steps of where you were before you watched this video. And if you like the tips, if you think they're helpful, please give them a thumbs up. And also don't forget to subscribe to the Command the Courtroom YouTube channel. That way you'll get notified each time a new video drops. So until next time, remember to keep on trucking and get out there and command the courtroom. I'll see you soon.